Here are 3 things you need to know if somebody whispers in your ear after receiving medical care and treatment and says, you should speak to an attorney. You want to know what this is all about? Come join me for a walk along the beach as I share with you the answers to those questions, or to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. So now you're receiving care and treatment from a doctor whom you trusted for a long time. However, during one of the visits, things took a turn for the worse. And at some point during that visit, somebody in that office turned around to you and said, you know what? You should see an attorney. You should speak to an attorney right away. Someone whispered in your ear, someone put a bug in your ear who said, listen, you may not understand what I'm telling you, but you should speak to an attorney right away. Here are 3 things you need to know if someone ever whispers in your ear and said you should speak to an attorney. Number 1, in order to determine if something was done wrong, we have to determine whether or not your doctor was careless, whether they violated the basic standards of medical care. Or to put another way, was your doctor negligent? And how do we do that? How do we figure out whether or not your doctor was in fact careless? Well, we have to get copies of your medical records. We have to get copies of not just your treating doctor's medical records, but doctor's records that you have treated with in the past, as well as any hospital records. And after reviewing all those records, our expert, a doctor whom we have chosen to review and analyze your records, has to be able to say, yes, this doctor was careless. This doctor departed from the standard of care. Now, is that it? Do you automatically have a case? The answer is no, which brings me to the second thing that you need to know. The second thing is that we have to then evaluate that if, in fact, your doctor was careless, that his carelessness was a cause of your injury. That's the second thing. Lawyers call that proximate cause or causation. And what is that? We have to show that there is an actual link between the doctor's wrongdoing and any injury that you suffered. That's known as proximate cause. We have to show that there is a bridge or a link, something connecting the wrongdoing to your actual injury. There might be wrongdoing that had nothing whatsoever to do with the particular injuries that you suffered. If that were the case, then we could not go forward and establish that crucial link that we would need to establish that, yes, the doctor's carelessness was a cause of your injury. So when our medical expert reviews all of your records, he is going to have to analyze not just whether the doctor was careless, but he's also going to have to analyze whether that carelessness was a cause of your injury or injuries. Is that it? No, there's more. There's much more. So you might be saying, wait a second, okay, what's the third thing? 1, 2, 3. What's the third thing that you have to be aware of? You have to be aware that if somebody whispers in your ear and says, hey, you should speak to an attorney who handles these medical malpractice cases on a regular basis, now has to determine whether or not the damages that you suffered as a result of any wrongdoing are substantial. If they are temporary, if they're bruising, and those bruises will go away in a short period of time, it is highly unlikely that any attorney in New York will be willing to go ahead and represent you and take on a case of your size. Now, why is that? It's a business decision. An attorney will spend just as much time prosecuting a case that has significant damages compared to a case that has very minimal damages or temporary damages. And because of that, the attorney is running a business, believe it or not, as much as they are fighting for justice for you. The attorney still has an office to run. The attorney has salaries, he has expenses. If the attorney that you are considering hiring now takes on cases that have very little or minimal damages, now it's going to be impossible to support a case like yours and to continue to pay his office staff and continue on with everything that happens in his office. It's simply not feasible from a business standpoint. So that's why you will find that most attorneys who handle these medical malpractice cases will not accept any case unless it has very substantial damages. So one of the things that we have to do, not just establish through an expert that there was carelessness, and not just establish that that carelessness was a cause of your injury, we also have to establish that your injuries are significant and or permanent. And only then will the attorney turn around and say, yes, We now have a medical expert who confirms that you have a valid case, and yes, your damages are substantial, and therefore we will agree to accept your case. And if we are ultimately successful in bringing this case in terms of settling it at some point prior to trial or going to a verdict, now we will receive a percentage of any amount of money we are able to recover for you. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this video because you want to see the beautiful sunset and the beautiful beach. No, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.